Who are we missing? Well, we'll give people another minute and we'll do roll call. All right, well, I guess we'll call this meeting to order here. It's 12:01 p.m. on Wednesday, December 9th. And I guess we'll do a roll call, see who we have here today.
Mr. Peterson?
Present.
Mr. Dunbar? Ms. Kennedy?
Here.
Ms. Allard? Mr. Constant?
Here.
Ms. LaFrance?
Here.
Mr. Chair, you have a quorum.
I'm here too, Mr. Chair.
Okay, fantastic. Great. Well, I believe the item we have on our agenda today is changes to Title 28. And Ms. Jones, if you want to lead that discussion, go right ahead.
Thank you, Mr. Chair. Before we get started on Title 28, I would like to just chat with the committee. And I think all of the assembly members know that the clerk's office is just working extremely hard to, frankly, keep up with the assembly. You're the ones that are doing all the heavy lifting and supporting your meetings till midnight, which we're kind of joking is the standard now. And you know, there have been a few times we've had a few snags, and but we've gotten through them all. Even so, I wanted to take an opportunity to celebrate, and this committee is the beneficiary of that celebration. And it's Erica has done the heavy lifting on drafting these revisions to Title 28. She's kept a small group together from May that's included Kate Vogel, Dennis Wheeler, Dean Gates, myself, Erica, and then we've occasionally pulled in Liz Edwards and Amy Solberg when we've had issues related to them. And so I really wanted to thank her for that. In addition, at one of your last meetings, there was a comment about a website for the committee. And I was reluctant to commit to doing a website for the committee because it means staff resources that are one place have to go someplace else. But I will tell you, I am just, again, so thankful for Erica, and she would like to talk to you about your new website.
Wow.
Thank you, Barbara. I have created a website for the Ethics and Elections Committee. It is accessible off of the Assembly Committee page where all of the committees are listed. And I will be keeping it updated with the agenda and any documents that the committee has listed on their agenda for their review. Unfortunately, I only was able to create it this morning, so there hasn't been a lot of lead time for today's meeting, but the agenda and the ordinance that we'll be reviewing today are both available on that website.
Well, thank you, Erica. And I was actually just talking to my assembly aide yesterday to see if he might be willing to help develop that website, but I guess you've sort of beat me to the punch on that. That's good news. All right, fantastic. So we'll have some more content available for people about ethics and elections, so they can, if they have questions or comments, they can get a hold of us about that. All right, well, let's move forward with our agenda. And who wants to lead the discussion today? Erica?
Yes, Mr. Chair, I will give you an overview of the ordinance, and then I think all of your staff will be fielding any questions that you may have.
Okay.
We did start looking at this ordinance. Let me pull it up on the screen. We did start looking at it maybe 2 months ago, but I think the version that was introduced yesterday at your assembly meeting last night is a little different from what we started looking at before. So I'm just going to start from scratch. And because it's 33 pages, I would like really to go over some of the highlights with you for things that really make a more significant change rather than going through page by page. So I will always reference what page I am on, and am always happy to take your questions. So I want to talk about sort of 3 overarching changes that go all the way through the ordinance so that I don't have to touch on them as we go through them later. One is changing the term accessible vote center to be just vote center. And you'll have seen that on almost every page of the ordinance. And this is because the word accessible carries with it some implications that we don't mean to bring to our vote centers. So that is changed. The second sort of language change is changing the phrase electronic transmission to the phrase fax and email. This is both a more clear explanation of what we're talking about, and it also doesn't create a conflict with the state law where the words electronic transmission actually only refer to delivery of a ballot, and that only by fax or through a website. So we thought fax and email would be clearer. And then the third wording change is in different places in Title 28, we use the term security envelope or secrecy envelope, and we are consolidating that phrase to secrecy sleeve. That's sort of the historical term used for that sleeve in which you put your ballot for privacy before you put it into the return envelope. And we're taking out the word envelope because we have a lot of envelopes in the code and we wanted to make it a little more clear. So those are sort of 3 overarching changes. And now I'm going to talk about more specific changes. So here on page 1 in section 1, 2810.020B, we are proposing to make explicit the clerk's authority to gather information relating to suspected or alleged election offenses so that the clerk has the information to determine whether or not the suspected or alleged offense needs to be referred to law enforcement. And there are similar changes on pages 12 and pages 21 in both places relating to sections of code that talk about receiving more than 1 ballot from any single voter. And so again, allowing the clerk to gather information about that situation and refer to law enforcement if appropriate. Moving on to page 4.
Mr. Chair, I have a question.
Go ahead, Ms. Kennedy.
Thank you. Erica, going back to that, the comment about reporting to law enforcement, I guess I want a little bit more explanation about specifically what that is intended to get at. If this is about, election offenses, I guess, is that defined anywhere in terms of what offenses are? Because I'm thinking that anymore, one of the things that I'm kind of thinking about is, okay, does that mean that if there's something fraudulent going on with, anything that might have to do with any kind of election fraud, or is it something more like maybe somebody's hanging out too close to a voting poll, carrying a gun, somebody's being threatened? I mean, anyway, can you give me some more ideas about really what led to this particular statement and whether or not offenses are actually defined? Thanks.
Through the chair, oh, go ahead, Ms. Jones.
Thank you. Through the chair, Ms. Kennedy, I can give you a couple of examples and the reason for this. First, last year we had a voter who came into the election center before it was closed, and I think it was last year, maybe it was the year before, and spit on all over the booths and the tables and on one of our election workers. And, I called the police for that. It's an assault. It isn't an election offense. It might be, but we reported that immediately. I don't think I need authority to do that. And then the other issue, specific authority, I guess I would say, the other issue here was an example that I've given you about allegations that Ms. Demboski made to us about a Facebook post. And in that Facebook post, it said, don't worry, I got your ballot at my address and I voted your ballot and my ballot. And so that is that's an election offense to vote someone else's ballot. And so Ms. Demboski turned that into us, and I did an investigation, and that's what this is authorizing us explicitly to do. And what I did was I looked up the name of the person to see if she was a qualified registered voter. She was. I got her address. We checked every day to see if any ballots came in from that address. And interestingly, no ballots did come in from that address that entire election, but we were monitoring that. Now, if a ballot would have come into that from that election and it didn't belong to that specific voter, but maybe belonged to that other person on that Facebook post, I want to make it perfectly clear that I'm entitled to gather that information and report it to law enforcement. And the reason that we've added this is that we are concerned that if we just contact law enforcement and say, here's this Facebook post that we think might be an election offense, we are concerned that APD or other law enforcement may say, well, we're too busy to handle that. Or how do we get them into our database since it's confidential? So all we're doing is just doing the basic inquiry and gathering the information that needs to be reported to law enforcement if there's a suspected or alleged election offense. And I did report the Facebook incident in my report to the Assembly. In all of the certification reports, we report all allegations of fraud to you.
Can I follow up a little bit then, Mr. Chair?
Yes, Ms. Kennedy, and I just wanted to mention that Ms. Allard has joined us.
Okay. Thank you, Mr. Chair. So Barbara, I've heard the example before about the Facebook post, so I appreciate that. And so I guess I think I understand a little bit better. I wanted to make sure that we weren't saying that there was some kind of suspected or alleged offense like the one you said to begin with, the assault one, that meant that you couldn't even call 911 if somebody came in threatening the well-being of other voters or something. So I want to make sure we weren't trying to say, oh, you have to have permission to call 911. But anyway, in talking about the other things that you think are more of the voter fraud potential, is that, I guess I just want a little bit of an explanation of the idea of reporting to law enforcement and where they actually come into this versus the Division of Elections. So how does, I guess I could use some background on how that actually happens in terms of when you've seen something that's actually fraudulent or somebody messing with potential elections. Who is the right one to go to? Who gets all the information about that? Who does the investigations?
Okay, so first of all, your
Thanks.
question about the Division of Elections, Ms. Kennedy. The Division of Elections is the state of Alaska, and nothing would be reported to the Division of Elections at the state of Alaska. So since the municipality runs its own elections, what would happen in the municipality is that the clerk would gather this information. And I will just tell you, our practice is, I believe that it gets reported to the municipal attorney and assembly council, and the municipal attorney supervises the prosecutor, and then there would be a decision about referring it to the prosecutor. It's possible that I could refer it directly to the prosecutor, and if we believe that it was sufficiently serious and important, we would absolutely include the prosecutor on that. Or we could just call APD, and then APD would do the initial investigation looking at the code to see where this fell. And then APD would probably, so it's kind of complicated about that, but it's a municipal election offense. So it's within the municipality. They could refer it to the FBI or to the state prosecutor. That's possible, but that wouldn't be something coming from the clerk's office.
Okay, got it. So yeah, so it would start here. And I guess that's always my, I don't know if it's a confusion or whatever, but trying to understand the real connection between the state and the municipality in terms of elections, because we do obviously rely on somebody being a registered voter with the state. So anyway, so that's kind of where I was trying to figure out where the connection was with the Division of Elections. But anyway, so no, that's helpful. Thank you, Barbara. So thank you, Mr. Chair.
You're welcome.
Thank you, Ms. Kennedy. Continue, Ms. McConnell.
Thank you. The next item to discuss is on page 4, and this relates to the time and method for elections. We are proposing in this section to clarify, so this is about the assembly calling a special election. So we're proposing to clarify the method by which this is done, which would be by a adoption of a resolution. And then instead of having what are probably sort of arbitrary timelines, we are proposing to replace those with references to the charter and code provisions that govern deadlines for various actions. And one of the important reasons for this is that the 30 days notice and the 45 days notice conflict with other requirements in the charter and code. For example, Title 28, Section 20040A requires that notice be published 30 days before a special election. But if the assembly calls a special election in 30 days, we won't have been able to meet the requirement to publish notice within 30 days. So there's various other, there's filing for office, requirements, there's time requirements related to initiatives and referendums and recall. So it makes more sense that a special election has to be called in accordance to fit with all of these other deadlines that are set in charter and code, rather than the days that are set in this section.
Okay, great.
Okay, moving on to page 9. In this section, we are proposing to reduce by 2 days the number of days that vote centers are open for a runoff election. And this is consistent with the general reduction of the election time period for a runoff election. We send out the ballots a minimum of 7 days, hopefully more, but 7 days prior. So it's the runoff election is just a shorter election. So we're proposing to reduce the number of days a vote center would be open to at least 5 weekdays prior to runoff election day.
Okay,
Moving on to page
Mr. Chair.
18.
Mr. Chair.
Ms.
I
Kennedy,
believe I think we have Dean Gates that wanted to make in the queue that wanted to make a comment about the special election, and I wouldn't mind going back to that myself. So if we could, please, thanks.
okay. Mr. Gates?
Thanks, Mr. Chair. Yeah, just really quickly, one reason that this will work well for us is because special elections can only be called by an act of the assembly by resolution typically. And so if we see the need for a special election, we need to call it. And this new code language will really help to facilitate whoever is drafting that document to call a special election, get everything right quickly and efficiently. And so I just wanted to mention how that is going to work very well for us. Thanks, Erica, for listing these out.
Thank you, Mr. Gates. Continue, Erica.
Mr. Chair, can I ask a question on that as well, please?
Oh, okay, Ms. Kennedy.
Thank you. I guess my question, and this probably for Mr. Gates, really. So is it already somewhere in code? I don't believe it's in the charter that says a special election has to be adopted by a resolution. I know we had a resolution to vote on in regard to the last time we addressed the potential for a special election, but is that already somewhere in code that it actually has to be a formalized resolution that establishes the date for a special election? And so we're really just matching this up with something that already exists, or did we just do that the last time to make it more formalized? Thank you.
So my quick answer is, I've been in the municipality so long that my memory is we had a section in code specifically like that for calling a special election by mail that said must be by resolution that lays out these things. But that section is no longer part of code. And so if you're asking what's really current, I sort of need to go and look and get back to you. But Eric or Barbara might have an answer off the top of their head in terms of what's in current code instructing how to call a special election. I actually think it's more implied because the assembly is the judge of elections and no other body can set one up, but it has to be the assembly.
I don't know off the top of my head. I'll leave that to Dean to get back to you.
Okay,
Thank you.
thanks, Ms. Kennedy. Continue, Erica.
Mr. Chair,
Oh, Mr. Constant. Go
thank
ahead.
you. So that certainly raises the question, depending on the nature of where Mr. Gates's analysis falls, that this might be the vehicle to add that if it needs to.
Right. Thank you.
Actually, if you look up here, the first line in B, line 27, 28, we're adding it right here, only by adoption of a resolution establishing a special election date. That's the way to call it.
All right.
Now, if it's somewhere else, I need to look. Sorry, was I audible?
Oh,
Yes, I think we're
Should I?
got some background noise here.
Are you ready for me to continue, Mr. Chair? I think
Yep.
Mr. Gates was going to do some research and come back to us.
Okay, great. All right, continue then.
Thank you. Okay, the next proposal I wanted to point out to you was on page 18. This section relates to voting by fax or email, but the change that I wanted to point out was a proposal to allow ballots received from what we are calling Muokava voters to be received by mail, as long as they're postmarked on or before Election Day, to be received by mail no later than noon on the day of the certification of the election. Muokava voters are defined as municipal, uniformed, and overseas citizens absentee voting act voters, which is a long acronym, but it includes members of the uniformed services on active duty and the merchant marine who, because of their membership in the service, are absent from their place of residence and are otherwise qualified to vote. The spouses and dependents of these uniformed service voters who are absent due to the member's active duty or service, and qualified voters who reside outside of the United States. So this is a group of people who are generally out of the country, and thus the mail may take longer for their ballot to return to us. So this proposal gives a couple of extra days for their ballot to come back to us and still be counted. So this change is proposed both here on page 18, which relates to returning a ballot received by fax or email through the mail, and a similar change is made on page 20, which just relates to a general ballot being received by mail.
Okay, great. That makes perfect sense. We greatly appreciate our military members, and we certainly want their votes to count if at all possible.
Yes, we do. And I've heard stories about how long mail can take to get from different foreign country, people in the military posted in different countries. Okay, and again, I know you'll all jump in if you have questions, and I'm happy to go backwards, but moving on. At the end of this page, you'll see a large portion of the code proposed to be deleted. This is a very detailed code about how ballots received by fax are processed. And not only is it really over detailed for the code, but in practice, we have found that we can do it slightly more efficiently if we do it a little bit differently. So we're proposing to take out these very specific instructions and just note that they are fax ballots are facsimiled and then counted in the same manner as other ballots as shown here in section I.
Okay.
Okay, moving on to page 20. In this section, this is about when a vote by mail ballot shall not be counted. And we have added one additional reason at the bottom, which is the voter did not provide required identification before the opening of the public session of canvass. And this relates currently you can register to vote over the internet. But in that situation, nobody has looked at your identification and verified your identity. So when that happens, the state gives you a status of ID required, meaning that somebody has to see your identification before your ballot can count. These voters get special voting instructions telling them that with their voted ballot, they need to return a copy of their identification. So when that comes back to us, it is flagged as we run it through the sorter, and we check whether or not they have provided a copy of their ID. If they have not, they get a cure letter saying, you were required to provide this, you didn't, please provide it no later than the public session of Canvas. If they do not provide it, if they do not cure that situation, we cannot count their ballot. So this is just clarifying that situation in code.
Okay.
Okay, moving on to page 21. In the section about question ballots, when somebody is required to vote a question ballot, they have an outer question ballot envelope, which contains a lot of, that they have to fill out a lot of information. They have to sign a they have to sign a voter declaration on the question ballot envelope. They have to sign the question ballot register. The election worker has to sign the question ballot envelope, and then the voter has to sign their ballot return envelope. So there's 4 total signatures with 3 similar voter declarations, and this is just ripe for accidental mistakes, like, oh, I forgot to get them to sign here even though they signed over there. And we don't think that somebody's vote shouldn't count just because somebody forgot a signature if we have a signature in a different place. So we are proposing to basically say, if the determination is made that the voter who voted a question ballot is qualified to vote, then the focus should be on their return ballot envelope, as it is for other voters, which goes through the signature verification process, and not as they shouldn't be disqualified if the election official forgets to sign or they forget to sign the question ballot envelope, as long as they have signed their ballot return envelope.
Okay.
Okay. Page.
Can we get clarification on that, please, Mr. Chair?
Sure, Ms. Kennedy.
Okay, actually, if you would just repeat again what you said about the difference between their actual ballot and the question ballot, and when you would count it and when you would not. Thank you.
Sure. So let me give you an example. If I move from West Anchorage to East Anchorage and I forgot to update my voter registration, so I go into a vote center and they say, what's your address? And I say, oh, it's blah, blah, blah in East Anchorage. And they say, well, your registered address is something else in West Anchorage. You have to vote a question ballot. So a question ballot is actually it's the same as a normal ballot. It's a completely normal ballot, but it goes into a question ballot envelope. It goes first into your normal return envelope that everybody's ballot goes into, and then it goes into a question ballot envelope. So it questions my qualifications to actually cast votes in the races that are on the particular ballot that I was given. So after the election, election officials review each question ballot envelope to determine, does the voter do they meet the qualifications to vote in the election? And the qualifications to vote in the election are set forth in the code. Let me see if I can find them quickly and read them to you.
Erica, that's okay. I understand the qualification.
Okay.
I want to get at the validity of a signature on an envelope, at what point it's needed or not needed. Thanks.
Thank you. So if the review of the question ballot envelope determines that the voter is qualified to vote, then their ballot in the ballot return envelope is taken out of the question ballot envelope and processed like all of the other envelopes. So it's run through the sorter, it goes to signature verification. If there's a problem with the signature, they are sent a cure letter to say, oh, you didn't sign the envelope or your signature doesn't match on the envelope. But if it does match, then their ballot is counted. Does that answer your question?
Sort of. You said something about one would not be rejected if it wasn't signed. So which one would you
So
referring to?
the question ballot envelope. So what we're trying to propose is that the focus be on the review envelope, the return envelope, in the same way that it is for all of the other voters.
So, Ms.
Thank
Kennedy, if you look at the section of the code here that Erica is proposing deleting, so this voter has moved and they voted a ballot in a ballot return envelope, just like we all do. And now it's put in this special questioned envelope. And one of the purposes of that questioned envelope, when they put the addresses on, is to update their voter registration to the new address. So that's important. But if you look at this section of code, it says if the voter fails to properly execute that question ballot envelope, their ballot doesn't count. And we're saying that is way too harsh because they have properly executed the ballot return envelope that we have all done, and they're qualified to vote. We should not be disqualifying those voters for what we're saying is in 1 and 2 that we're recommending to delete are technicalities.
Okay, so what I'm trying to make sure of is that there is a signature on one of those envelopes or the other. So in other words, you're telling me that there would be a signature on the regular envelope. There just might not be one on the question ballot envelope.
Right.
And so therefore it would still be a valid vote because you have a signature of some sort on one of those envelopes.
Ms. Kennedy, that is essentially correct. Remember that if a voter didn't sign that ballot return envelope, the election team would be sending them a cure letter so that they could cure that. But then, of course, yes, that signature must match, and so we're double checking it. So ultimately, yes, that ballot return envelope has a valid approved signature.
Okay, okay. I think I got it now. Thank you. Sorry for all the confusion, but I appreciate the response. Thank you, Mr. Chair.
Thank you, Ms. Kennedy. And I just wanted to say that if we had same-day voter registration, we would no longer have question ballots, or probably. So anyway, continue, Erica.
Thank you. On page 22, under the section regarding ballot adjudication, we are proposing to update the graphic, and it's a very simple update. It's just adding that a heading to the top one that's a race, and the second one is a proposition. So it's, other than that, they're identical. And then we are adding language, information about how to invalidate a vote if a voter has voted and then they decide that they don't want to have voted in that race or measure. So if I cast a vote for John Doe and then I change my mind and I say, no, I don't want to vote for either John or Mary, we're instructing them how to change their ballot so that no vote will be counted. And then this language in B is just moved to a new number 7. And of course, if somebody does make a mistake when they're at a vote center, they can go and request a new ballot. But if you're voting at home, you would then have to actually go to a vote center if you wanted to get a new ballot.
Right.
Any questions about this? Okay, moving on to page 24. This looks like a lot of changes in this section on public session of Canvas, but really it's just taking this big paragraph and dividing it up into an order that makes a little bit more sense about what happens at the public session of Canvas, and then also adding a deadline for sending notification letters to those voters whose ballots were not counted. So when the election commission votes to reject certain ballots, they reject ballots that were postmarked after election day, they reject ballots that weren't signed and weren't cured, you know, that sort of thing. We then have to mail a letter to each voter saying, your ballot wasn't counted and here's why. So this adds a deadline that we have to get those letters out within 30 days of certification of the election. Okay.
Ms. Kennedy, do you have a question?
Yes, maybe a suggestion. Thank you, Mr. Chair. In D, it says the vote of the election commission is final. Do we want that to say the vote, or do we want that to say the decision? Because they're not really, well, I guess they are kind of voting, but it seems to me, I don't necessarily want to confuse the idea of voting with the fact that the public just voted versus the fact that the commission is basically canvassing all of the votes and coming up with a decision as to whether or not it was a valid election. So anyway, just throwing that out for thought. Thanks.
Thanks, Ms. Kennedy.
Thank you.
If I may, Mr. Chair.
Go ahead, Mr. Gates.
Thank you. So you see here that section 288510, it's omitting from the document subsections A, B, and C. So subsection D, Ms. Kennedy just referred to, it sort of tracks what's in the previous subsection C, and I'm reading it out to you. The election commission by majority vote may accept a ballot or refuse to accept the count. The commission may accept a partial ballot. I'm skipping a little bit, but it basically starts by saying the election commission by majority vote. And so D just sort of tracks that process and language. The vote of the commission referred to in C is final. Yes.
Okay, that makes sense. So thank you.
Okay, thank you. Continue, Erica.
Thank you. On page 26, this is the section about recounts, and we are proposing to change the deadline for recounts rather than being 7 days after the election commission adopting its report. We're proposing to change it to within 7 days after the certification of the election. That is a more sort of publicly noticed and clear event that sort of gets a lot more attention. And so we think setting the deadline starting from the Assembly's action on certifying the election will be more clear for the public. Lower down on that page, we are proposing some changes to what triggers an automatic recount. So current code says that an automatic recount shall happen if the results show that a candidate, proposition, or measure wins or passes by less than a 0.5% margin. And clearly the idea is that if the result is very, very, very close, then you do an automatic recount. Well, there are other situations where a result could be very close, but that would be very significant, but wouldn't fall in this wouldn't fall under this. So examples include a candidate receives less than 0.5% over the required margin. A candidate by charter has to receive 45% plus 1 of the vote. So if they receive 45.2%, that is very close. And so we are proposing that that would trigger an automatic recount. The next situation would be if no candidate has achieved the required margin, so there's going to be a runoff. Well, the person who's in second place is very interested in that, and if there's a very close margin between the second and third place candidates, then there would be a required recount to ensure that we're getting the correct second place candidate onto the runoff. I'm sorry, did I say recount? I meant runoff election. And then the last situation would be if a proposition or measure passes or fails by less than a 0.5% margin, again, where you have that very, very close vote, that these things would all trigger automatic recounts.
Do you have a question, Ms. Kennedy?
Yes, thank you. I like the fact that you're adding in, the specification over the candidate. We obviously already do that with the margin. I mean, I'm glad you're adding it with the candidate over the 0.5% over the required margin, because we obviously already do that with like an initiative. But in number 3, when no candidate has achieved the required margin, could we put another statement in there then that says, and which triggers the need for a recall, and then put this, just put that in there between then the second and third place candidates are separated by less than 5%, because it's a little bit confusing to read that. When no candidate has achieved the required margin, then it sounds like, okay, now you're just going to focus on the second and third place candidates, but you're not necessarily saying that, well, they're obviously that triggers a runoff. So I think I used the wrong word a minute ago, but anyway, when it triggers the runoff, I'm just thinking that just for purposes of clarification, just to specify that that's a situation where it would require a runoff. So that's my thought. Thank you.
Okay, thanks.
Thank you, Ms. Kennedy. Any other questions on this section?
Dean has his hand up, I think.
Okay, Dean, go ahead. Mr. Gates? Well, I'm not hearing Mr. Gates. I see Ms. Jones has her hand up. Would you have a question or comment, Ms. Jones?
Nope, that would be a mistake, Mr. Chair. Sorry.
Okay. All right, I see Mr. Gates' hand has come down, so I guess continue, Erica.
Thank you, Mr. Chair.
Yes, sorry. I think that was clicked by mistake.
No problem.
On the next page, similarly to what we did for a recount in changing the timeline to start at the certification, we're proposing the same thing for submitting an election contest, that it would be submitted within 9 days after the certification rather than the adoption of the Election Commission's report.
Okay.
And we are now getting into sections about election offenses. And I know, Ms. Kennedy, you had asked much earlier whether there were election offenses set forth. And so there are a number of sections regarding election offenses. And they start, or at least the changes we're proposing start generally on page 29. On page 30, we are proposing that to add that tampering with a drop box is an election offense. And on page 31, we are proposing to add 3 elements of voter misconduct to voter misconduct in the second degree. These 3 additions are all consistent with state law, but we prefer to have them in our code so that we have control over them, whether we want to push for prosecution, whether we want to prosecute them ourselves, rather than sort of handing over that power and authority to the state. Although, as Ms. Jones mentioned earlier, we could certainly refer things to the state law enforcement if we so desired. And then the last significant change is on page 31. Sorry, page 31. I'm sorry, page 32. So improper subscription to a petition. The fourth crime is soliciting, accepting, or agreeing to accept money or other valuable thing in exchange for signing or refraining from signing a petition proposing an initiative. We are proposing to add that this would also be the case in a petition proposing a referendum or a recall. And with that, Mr. Chair, I've hit the highlights of this ordinance. Obviously, I've jumped over a lot of things, and I'm happy to answer questions about anything, but I do feel like I've hit the major changes, and a lot of the things that I didn't touch on are less significant or just rewording that don't make significant changes to the meeting.
Well, thank you, Erica, and it was a good presentation. Mr. Constant has a question, I believe, about page 2, line 41. Go ahead, Chris.
Yeah, thank you. So I don't know if I just somehow missed us going over that part, but there was a definition I didn't understand, or a line. So voter declaration means a statement of the voter no, that's not it. Yeah, that's it. A statement of the voter qualifications listed below to which a voter swears or affirms under penalty of unsworn falsification by their signature or mark. Is unsworn falsification an actual violation?
Through the chair, Mr. Constant, yes, unsworn falsification is a misdemeanor, and it's listed in our code in Title 8. And we propose changing this from perjury to unsworn falsification because perjury is a felony, which is not enforced by the municipality, and unsworn falsification is a misdemeanor, which we can enforce. And I can get you the exact Title 8 reference.
I'm just trying to understand how the voter swears or affirms about an unsworn falsification, but if unsworn falsification is an offense and they're swearing, I guess this is where Dean can describe how this functions.
Do you have a comment on this, Mr. Gates?
Yeah, I had seen Mr. Constant's comment in the chat, so I was looking into this earlier during the discussion. Well, first I wanted to say this is really, the declaration and that penalty is very similar to state law. AS 152030 also has a voter certificate as a subject. It needs to have a notice that false statements by the voter are punishable by law. And so we sort of are tracking the state law as well. And I guess how this works, unsworn means the statement doesn't have, you know, the under oath or affirmation or under a notary, and that's where it's a sworn statement. So an unsworn statement would just be the paper that has a notice, you know, unsworn, a falsification. So you have something false that you've entered, and for here, it's like I'm qualified because I'm a citizen of the US, resident of Alaska, a resident of MOA for 30 days preceding the election. But if I've only been a resident of the MOA for 28 days and I sign this, then that's sort of actionable. That violates it because although I haven't sworn to this statement, I'm lying. It's false that I've been a resident for more than 30 days. And so I guess if I'm caught, then this would be punishable under this provision and under that Title 8 offense of unsworn falsification. So I hope that that was a clear explanation.
So the part that throws me then are the words swears or affirms. Wouldn't it be attests? Because we're saying this is unsworn. I'm confused about the actual language, and so maybe it's not really an issue, but if they're swearing, then it's sworn.
Well,
You know, I'll have to say that what the wording is a little bit hard to understand when you first read it, no doubt.
And so would the word attests fit? Because then functionally it would make sense if voter attests under penalty of unsworn falsification by their signature on this mark. I swear by an unsworn qualification. It just doesn't make sense to me, but I'm not an attorney, so I'll leave that to you guys.
This is the,
Thank you. Do you have a follow-up on that, Mr. Gates?
yeah, just briefly, I'm looking at the code section, and yeah, I think that we maybe wordsmith this a little bit. So we will let you know if we make a change. Thanks for identifying those words, Mr. Constant.
Okay, great. Thank you, Mr. Gates. And I believe Ms. LaFranca's got a question.
Thank you, Mr. Chair. A comment and a question. First, a comment on striking through to invalidate a choice. I didn't realize that was an option and that the machine would, I'm assuming, would read that when someone crosses through the one that they don't want and fills in the other oval. I mean, probably just from growing up in the standardized test time where, you know, it invalidates your whole thing. So that's, I'm happy to see that. And then a question on the intent to vote more than once on page 31. I'm just curious as to like, how would that intent be identified or established? I know that sometimes when people, you know, like in the recent election at the state level, there were concerns that, you know, if the ballot wasn't received by mail, you know, maybe go vote in person to ensure that it's received. And that wasn't necessarily, I don't know that that even necessarily happened, but, you know, in some of the cases concerning that discussion, it was more just to ensure that a vote was received. And so I'm just curious as to how that intent would be identified or established of someone wanting to, you know, vote more than once. Thank you, Mr. Chair.
Thank you, Ms. LaFrance.
Through the chair, this is Barbara. I'll attempt to answer Ms. LaFrance's question. Ms. LaFrance, every year we have voters who vote twice, and we also report that to you in our certification request. And basically what happens is sometimes people get a ballot mailed to a temporary address, they get a replacement ballot, they hear that it's election day and they go to the vote center. And we have looked at the ages of those voters, and many of them are older. We also have had in the past situations where we understand that people who have intellectual disabilities have voted twice as well. Those people are going to get a letter within 30 days from the election commission rejecting one of those ballots because we know they voted twice. That's all the action that we take at that time because it doesn't appear to us that this was, as you said, intentional. It appears to be a mistake. And the second ballot isn't counted. So if the clerk's office did some type of an investigation into this and discovered that, no, this does look different than those examples, we would be referring that to the municipal attorney and assembly council and the prosecutor, as we discussed earlier, and then it's up to them. Intent is an element of the crime. And that would be something that they would have to decide, you know, before they prosecuted or during that type of a matter. That's not an issue for the clerk's office.
Okay.
Thank you, Ms. Jones, and thank you, Mr. Chair. And I just wanted to say thanks to all the folks who worked on this legislation. Clearly, a lot of time has gone into it.
Thanks, Ms. LaFrance. Now I see Ms. Kennedy has a question.
Thank you, Mr. Chair. Ms. Jones has made me kind of wonder about a scenario that I guess could potentially happen, whether somebody would be forthright in saying this. But, you know, because we have potential for sending in multiple ballots, I guess you could say, if somebody were to vote and then decide they had they didn't want the vote that they had, and so they wanted to change their vote. And of course, you can't typically do that, but if somebody did it in such a way where they went in and sent in another ballot and said, oh, well, just don't count the first one I sent in. I might have voted twice, so just don't count the first one, count this most recent one. Is it possible for a situation like that to actually develop? And if so, how would you treat that? Whether somebody was actually telling you that they were doing that intentionally to change their vote, is there potential for that to happen, that somebody could vote a second time in the hopes that they would be able to actually change their original vote? Thanks.
Absolutely, Ms. Kennedy. That happens all the time. It happened in poll-based elections. But the code specifies how we count and process the ballots. And Erica, do you know that off the top of your head, which ballot gets counted first?
Yes, it's the first one we receive is counted, and that is stated multiple and replacement ballots consistent with 2850 140B. The first valid ballot received is counted.
Okay, thank you. And that helps. I guess I was just thinking how somebody might try to game the system a bit, but it sounds like that's really not possible. So thanks.
Ms. Kennedy, they're going to get a letter that they voted twice and the second one didn't count. And in our opinion, that is at this stage where, you know, we consider it part of the mistake. It's not going to be something that we're going to refer to the prosecutor. You know, we could if we had 1,000 of those, we may talk to the municipal attorney, but then again, it would be up to the municipal attorney and assembly council what to do with that.
Thank you.
Okay. Thank you, Ms. Jones and Ms. Kennedy. We are a couple minutes past 1 here. Do we have additional information? So do we need to extend, or are we close to finish today?
Mr. Chair, I have nothing additional for you on this ordinance.
Okay.
Mr. Chair, you probably do need to do audience participation. I think we have a couple people on the phone for that.
Okay. All right. Can I get a motion to extend for 10 minutes?
Move to extend for
So
10
moved.
minutes.
Second.
Okay. All right. Thank you. So we're extended for 10 minutes. And if anyone has a comment to make, go ahead and unmute yourself and introduce yourself, please. You have 3 minutes.
Hello, can you hear me?
Yep. Is that you, Mr. Haberman?
Yeah, but I think someone else was trying to speak, so why don't you let them first?
Thank you. My name is Louis Imbriani. I was just reviewing section 2850 120, and I would think that similar language would need to be added with 2870 030. It's about providing, marking, returning, and delivering the ballot. There's nothing stating with a valid signature in that section of 2850 120, but there is in the 2870 030. It just would allow similar language about what a valid vote looks like and how to return a valid vote, keeping it the same in code. That's all that I have. Thank you.
Thank you.
Hello?
Is that you, Mr. Haberman? Go ahead.
Okay, I said my turn. Footnote one is, my name is Eugene Carl Haberman. I follow the public process. When the public process is done appropriately, decision made by the governing body is more like the public interest. One to note, yes, thank you for finally putting a site for the election committee, ethics election committee. As noted, it was put on today, but finally it added so that when you addressed items on the agenda, like there's legislation that is going to go for public hearing, The public can follow what you're in your discussion in this meeting, whereas not being at a distance and follow exactly where you're coming from. Second is this, the item was read last night for introduction. I didn't hear when it's scheduled for public hearing. I would encourage you to have at least 2 public hearings and also give some time for the public to be engaged. Also remind you on the history is, I remember times when you do major legislation changes of elections, you bring the whole assembly committee, the assembly together, and then I can't help but notice such an important piece of legislation dealing with elections that there's only a few members of the assembly as party to this meeting today, and the rest are out of the picture. And one would have thought that this would have brought the committee as a whole on this before going into public hearing instead of just assembly committee, because it's gone for reading on December 8th. And then last thing to say respectfully, I signed up remotely, one for initial ordinance participation, and then I noted, unless I witnessed the meeting last night, that the chair did not contact people by phone in the initial, and definitely not in the final, till I was out of the picture to address. And there were several things on the consent agenda that you addressed, and unfortunately, the public who was asked to participate by telephone were distant and could not speak. And that's all I have to say, except happy holidays, and I wish you all the best.
Okay, thank you, Mr. Haberman. Is there anyone else would like to publicly comment? Or do you have your hands up, Ms. Jones? Do you have a comment or a question?
Mr. Peterson, if I could just make a comment before you adjourn after the public audience participation.
Okay. Any other member of the public want to participate? Not seeing anyone. Proceed, Ms. Jones.
Thank you,
Chair?
Mr.
Hello.
Hello, introduce yourself. You have 3 minutes.
My name is Susan Riley. I am, until 2020, an election volunteer, and I also happen to be the current president of the Alaska Alliance for Retired Americans. I just like to thank you for including me in this meeting today, and this is near and dear to the heart of most people of my age group, and so I just wanted to let you know that I intend to continue to participate in this process. Thank you.
Thank you. Anyone else, a member of the public with a comment? Okay, Ms. Jones.
Thank you very much, Mr. Chair. The last thing that I just wanted to let members know, because we had to cancel your November meeting because it was the day before Thanksgiving, we had anticipated that the committee would have reviewed this then before this ordinance was introduced. But because it needed to be changed, you haven't seen it. So we would like to know, and you, if any of you would like to be added as sponsors to this ordinance, and you can either shoot us an email to let us know that, or you can tell us on the record. Thank you.
Yeah, I'm a sponsor, I believe. Any other member of the committee would like to be a co-sponsor, we would certainly appreciate that.
Mr. Chair, this is Suzanne. I would be happy to co-sponsor as well.
Fantastic, appreciate it. Anyone else? Okay, well, we're just about to 10 after 1, so I believe it's time to adjourn. And so have a great rest of your Wednesday today. Thank you.
Thank you.
Thank you. Bye.
Return.
See you
Thanks
later, everybody.
all. Bye.